Good evening, everyone. Welcome to the Eisenhower Presidential Library. Thank you for being here with us tonight. I'm Dawn Hammond. I'm the director here at the library, and I'm pleased to have you with us tonight for this event. Let's do a little bit of housekeeping, please. Take this moment to silence your phones. I'm going to have to do it as well. So let's take a little moment. Everybody get your ringers out of your pockets. Also, on the chairs, when you came in, there were some surveys. These survey forms are really important to us at the library. They help us determine perhaps programs that you would like for us to do in the future, and your thoughts on this program that we had tonight. So when you, at the end of the program, if you would be so kind as to fill those out, and Pam in the back will take those up, and she will use those to make some future decisions. So thank you very much. I'd also like to thank Eagle Communications for filming tonight's program. It will air on one of the Eagle channels in the future, probably in the next 2 weeks or so. Once we have the date of its airing, we will post it on our Facebook page. We will also get a copy of that and have that on our YouTube channel, which is at Ike Library. We are so pleased that we are able to partner with different organizations, different community organizations, to create relevant programming like this. Free speech, free press, and free society is a very important issue to us. It was important to Dwight Eisenhower, and it's important to us even today. We're grateful for our partnership with our friends in the 1st Infantry Division at Fort Riley. We love the big red one. In particular, we'd like to thank the team at the Office of the Staff Judge Advocate. Captain Thomas Wheatley has been a tremendous asset in making this program a reality. Where is? Thank you. Not only did he arrange for all of the speakers, but he even found the perfect moderator for tonight. So let me introduce our moderator. Colonel Dunlap is the Staff Judge Advocate General for the 1st Infantry Division at Fort Riley. Prior to that, he served in the Pentagon as the Chief of Career Management for the JAG Division. Please help me welcome Colonel Dunlap to moderate our discussion.
Good evening, I'm Jerry Dunlap, a Big Red One soldier, and as introduced, the Staff Judge Advocate for the 1st Infantry Division in Fort Riley. I'm really excited to serve as the moderator this evening for such a distinguished panel, particularly to discuss this topic, the 2019 Law Day topic, free speech, free press, free society, which focuses on those cornerstone issues that are so important for a representative government, and calls on each of us to understand and protect those rights to ensure that as the Constitution proposes the blessings of liberty for ourselves and our posterity, it's really fitting that we're here at the Eisenhower Presidential Library and near President Eisenhower boyhood home, as he actually established Law Day in 1958 to mark the nation's commitment to the rule of law. As the former Commander-in-Chief of Allied forces in Europe during World War II, and then as the Commander-in-Chief during some of the darkest days of the Cold War, President Eisenhower wanted to celebrate the rule of law on the 1st of May to contrast that of the May Day celebrations that the communist world had. And so he wanted a holiday that, quote, distinguishes our government system from the type of government that rules by might alone. He continued, the world no longer has a choice between force and the rule of law. If civilization is to survive, it must choose the rule of law. Given this background, I'm honored to introduce our panel, and then we'll open the floor to you after their opening comments for this topic of discussion. We'll start off with Stephen McAllister, who is the United States Attorney for the District of Kansas. He was sworn into office on the 25th of January of last year. Mr. McAllister has served as the Solicitor General for the state of Kansas. Before that, he was also a professor of law at the University of Kansas. He's argued before the Supreme Court 9 times. He was also a clerk before the Supreme Court for Justice Thomas and Justice White, and he also was a clerk for the Seventh Circuit for Judge Posner. And obviously a Jayhawk at his roots. He received both his bachelor's and law degrees from the University of Kansas. So Mr. McAllister, welcome, and any remarks you have.
All right. Well, I'm going to just do a couple of things by way of introducing. And the first thing I want to do is, Department of Justice requires me to say this. I'm going to speak in my personal capacity tonight. So these are not official positions of the United States or the Department of Justice. But we need that. The first remarks I'd like to make is I think the Supreme Court has had a remarkable commitment to giving the First Amendment as full of an effect as it possibly can. And that has seemed to hold true over considerable amounts of time and certainly over a spectrum of justices. I mean, if there's one issue at the Supreme Court that can really unite liberals, conservatives, moderates, it often seems to be freedom of speech, and they all protect it. So I wanted to give you a couple examples that I think are pretty remarkable in demonstrating that commitment, and then I want to talk a little bit about some modern challenges, and there I'm going to veer towards the U.S. Attorney territory and tell you about some things we're encountering in that world. So the first is a quote from Justice Kennedy in a case called United States versus Alvarez, which made it a federal crime to falsely claim that you had won the Medal of Honor. And there are a lot of people out there, apparently, who would like to make such false claims. Alvarez was one. He's apparently a born liar. He lied about everything, and he liked to say he won the Medal of Honor. He was prosecuted under federal law, and the Supreme Court struck down the statute saying you could not make it a crime to make that lie. And there were some pretty substantial arguments about the importance of such an honor and honors in general within the military system and what it means to our military. Justice Kennedy says, the nation well knows that one of the costs of the First Amendment is that it protects the speech we detest as well as the speech we embrace. And so they said he could not be prosecuted for lying about his honors. The second case, decided just a year before that, hits closer to home and also involves the military in a way. And that's a case called Snyder versus Phelps, in which the Phelps family out of Topeka decided, because they were getting a lot of attention, that they would protest at funerals, particularly military funerals. As you know, if you were around during that time, very controversial, horrible things that they put on their signs and in their protests, hitting families and others at a very vulnerable moment. They were sued for violating what's called tort law, personal injury law, Maryland law, and a jury gave the plaintiff, the father of a Marine who was killed, a very substantial amount of money. The Phelpses appealed all the way to the Supreme Court, and the Supreme Court said you cannot award money against them because they were in a public place. They were on a street corner where local officials had told them they could be, and they were addressing issues of public concern, albeit in their really hateful, nasty way, but they were talking about issues that are out there. And I like Chief Justice Roberts at the end of the opinion, striking down the judgment against the Phelpses, says speech is powerful. It can stir people to action, move them to tears of both joy and sorrow, and, as it did here, inflict great pain. As a nation, we have chosen a different course than punishing the speaker. We protect even hurtful speech on public issues to ensure that we do not stifle public debate. So I think we have a pretty profound commitment, both through the Constitution and the Supreme Court as its guardian, to protecting freedom of speech. So let me segue to how this has come up for me, at least, in the U.S. Attorney's Office. We see lots of hateful things out there. The FBI has its eyes on as much as it can, whether it's Facebook, it's Twitter, it's all sorts of things. We see lots of hateful messages. What can we do about that? Well, the First Amendment says not much, as long as it's just speech. The Supreme Court has held it has to be a true threat before you can make it a crime. So just because somebody says, I'd like to kill a bunch of people, if it's not supported by other indicators that they actually intend to follow through on that, there's nothing we can do about that. So it comes up in the context of the threats against schools, threats against certain groups, say Muslims or immigrants. We see that stuff all the time, but the FBI and the Department of Justice has to be particularly careful in investigating those things because by and large people are engaging in protected speech. We can reach it, like I said, if it's a true threat. We can reach it if it's a hoax. We had that in Wichita, and this is the digital world amazing me. So 2 kids gaming online together, one in Wichita, one in Cincinnati. They get in a fight. The one in Cincinnati reaches out to a guy in Los Angeles and says, I want you to swat the kid in Wichita. I didn't even know what that was before I took the job. Well, the kid in California calls emergency services and tells the story. I've killed my father. I've got my mother and brother held hostage here in a house in Wichita. I'm going to light the thing on fire. Police respond. None of the actual actors are in this house. It's a family that has no idea of any of this. And one walks out on the porch. There's yelling, confusion. The officer fires a shot and he's killed, the guy on the porch. We can reach that because that's a hoax. So bomb threats and those kinds of things, we can reach. And then the other example I want to give you where it's tricky for us, you see a lot of anti-this and anti-that rhetoric, whether it's white supremacists or it's anti-Muslim or it's anti-immigrant. Well, we had a case out of Garden City where we had 3 fellas who ended up plotting to bomb a Somali apartment complex that was inhabited by Somali refugees working in the meatpacking plants in Garden City. Now, they can talk all day long about how they don't like Muslims and the things they'd like to see happen and so forth, and we can't really do anything about that. Fortunately, the FBI managed to get an informant within the group so that we could monitor what they were doing. But again, we couldn't do anything because of the First Amendment until they took actions to carry out their plan, which they did. They ultimately built a detonator. They then wanted to buy materials for an explosive, and the FBI was in at that point providing an undercover to pose as basically an arms dealer. But we had to see the point of action. So my point is the First Amendment protects an awful lot of stuff, some that is even headed towards the criminal realm. But we can't just, because people said it, necessarily do anything, or we'd be in violation of the First Amendment. So rightly or wrongly, and I don't say that I always agree with protecting all speech, but rightly or wrongly, that's largely where we are. They're very narrow categories and exceptions where we can criminalize something that is speech, or it has to be more than speech. Speech plus action, that's different. Speech alone, no. And so you also see part of the challenge for law enforcement when you have somebody who says, I think I want to go shoot up a school. Well, we can go out and talk to them and try to figure out if they're a real threat or not, but we can't do anything criminally just because they made such a statement. So it's a daily challenge for us in trying to keep people safe. Thanks.
Thank you, sir. I'll now introduce Major General Tom Romig. He is a native Kansan from Manhattan. He served as the Dean of Washburn University Law School from 2007 to 2018. He previously worked as Deputy Chief and Acting Chief Counsel for the Federal Aviation Administration. And prior to that, he was the 36th Judge Advocate General for the U.S. Army, so my corps in the Army. He was a 2-star general, the senior uniformed military attorney for the Army. After a very distinguished career there, he retired from the Army JAG Corps in October of 2005 after 34 years of service. In June of 2009, the Kansas Bar Association awarded General Romig its Courageous Attorney Award. This was awarded to General Romig for his time as the Judge Advocate General for the Army when he took positions against waterboarding and other extraordinary methods of interrogation that were in violation of the Geneva Conventions and the Uniform Code of Military Justice. General Romig.
Thank you, Jerry. Well, first, I guess I'd like to say Happy Law Day to everybody, and thank the 1st Infantry Division, JAGS, the Office of the Staff Judge Advocate, and the Eisenhower Library for inviting us here and for all of you to be here celebrating free speech, free press, and how they are to a free society. And I thought I'd look a little historically at the First Amendment. And there are 6 clauses in the First Amendment. The first 2 deal with the religion, the Establishment Clause, that the government will not establish a religion, and the Free Exercise Clause that allows prevents government from abridging the free exercise of religion. But the others all deal with themes that really impact on the ability of people to participate and function in a free society, a democratic free society. And they are free speech, free press, the right to peaceably assemble, and the right to petition government with grievances. And all of these are critical to the ability to have citizens participate in a free government. Now, you might wonder, why would this all be in the First Amendment, and what were the founders, what were the framers thinking about? And if you remember back, they had just gone through an experience during the Revolutionary War and even leading up to the Revolutionary War, where they had been dealing with the British Crown and had many grievances, many of them found in the Declaration of Independence, grievances with the Crown and the British government. So there was a great distrust among the founding fathers of a strong central government. And they wanted to make sure that the rights of the people, a key element of democracy, the rights of the people were established early on in the Bill of Rights as critical to what they wanted to do with this new government. And I've heard it said that it's sort of like a marketplace of ideas. I think it was one of the justices in a Supreme Court case talked about the marketplace of ideas, that free speech, free press particularly, allow people to express ideas, hear information, and then effectively participate in the government that the founders wanted so much everybody involved in. So if this marketplace of ideas is one of the cornerstones of free society, it's important that the press be able to go out and investigate and educate the public as much as they can about what's going on, what their government is doing, and for the public then to be able to hold the government accountable if there are things that they are concerned about. None of this would be possible if we didn't have free speech and the freedom of the press. One of the challenges for us now, moving forward in time, is the rapid growth of technology over the last few decades. We have new forms of communication, we have new delivery methods, speedy delivery methods, and it all raises challenges for the law, and these are all things that the founders would have never thought possible. They would be stunned with the diversity of technology and the impact on communications and all that. One of the things we hear a lot about today is the term fake news. And I decided I'm going to Google this and see if I can find out anything about where this term came from. Well, it turns out it's been around as long as we've had communications between people. It's also called yellow journalism, it's called sensationalism, propaganda, among many other terms. So it's not anything new, but the means of delivery and the speed of delivery are what are the really big challenges. And the real danger is as the founders feared, you do not want a central government putting out what is true and what is not by also engaging in fake news. So that's the real danger. And it brings to mind a quote I remember from college studying modern Europe, a quote by a guy by the name of Joseph Goebbels, who was the propaganda minister, or as they called it in the Nazi government, they called him the Minister of Public Enlightenment. And he is on record as having said, if we tell a big enough lie often enough, the people will believe it. And that's the danger today with the new forms of media that can get information out there quickly, be false, difficult to find out what the truth is, and makes it a challenge to get your information from this marketplace of ideas. So with that.
Thank you, sir. Professor Franciska Coleman is a visiting assistant professor at the University of Kansas Law School. She's an interdisciplinary scholar whose work draws on democratic theory, literacy theory, and constitutional law. Professor Coleman received her JD from Harvard Law School and her PhD in literacy, culture, and international education from the University of Pennsylvania. Professor Coleman taught American constitutional law in South Korea from 2011 to 2017, where she worked closely with the Korean government on several initiatives, including as international roundtables on offensive speech. She recently held a visiting scholar appointment at Harvard Law School during the spring of 2018. Professor Coleman.
Okay, so I'm going to begin with a little vocabulary. When we say free speech, a lot of times people think that means free from regulation. And that's not quite accurate. It means free from government regulation. So the government can't pass a law telling you what's acceptable and what's not acceptable to say, but it's not free from social regulation, which means social pressure in your local community to conform to speech norms. So one example would be, if I have a bad habit of making disparaging remarks about religious minorities, the government cannot criminalize my speech. They cannot fine me. They cannot arrest me for making those remarks. But what can happen is one of my neighbors can take a screenshot of my disparaging Facebook post. They can tweet it to the corporate headquarters of my company, and I can lose my job. Now, that doesn't sound free to me. That actually sounds very, very costly. Now, as a matter of First Amendment kind of theory and ideology, social regulation of speech is fine because there's not this national coercion to kind of unify thought and unify ideas. Ideally, right? It's just individual local communities, individual citizens trying to bring social pressure for conformity, but not this kind of widespread national conformity to a single idea. But then you kind of come to today where we have a different form of social regulation, right? It's not the individual citizen. Instead, social regulation has become institutionalized, right? We want Facebook to kind of throw you off their platform. We want PayPal and GoDaddy to, kick you off the internet. So this then becomes, this social regulation begins to look a lot like government regulation. And people have a sense that, wait, this cannot be allowed. Like, this is censorship that's supposed to be prohibited by the First Amendment. But it's not prohibited because it's not actually the government. It's just institutions that are national and multinational that have the power that's very similar to the power wielded by the government. So there are a couple of solutions that have been proposed to this problem, right? One solution is they look like the government. They have the power like the government. They are censoring me, with the effect of government censorship. So let's treat them like the government, and let's make them stop censoring people, subject to the limitations that Professor McAllister Stephen has told you about. So we want to do that. Now there is a lot of pushback on that because in this time of super polarization, hate speech plus polarization actually leads to very severe harms to these minority communities. So there's a lot of tension around saying we're going to tell Facebook, don't kick people off of your, site, as, former dean, I forgot your name, Tom said, if you say it often enough, right, and if you kind of keep hearing it, then you kind of be like, yeah, this is right, they really are taking over, and you feel like you have to go in, so we don't necessarily want to kind of get rid of this kind of social regulation. What we want to do is improve it. And so one problem that people have is who is making these rules at Facebook? Is it, Zuckerberg? Like, who are these people? And you get into this on these university campuses. Who's in the diversity and inclusion office who's telling people what kind of words they can use? That really makes people feel censored. But what if we could take a different approach? Professors Fishkin and Ackerman have an idea they call deliberative polling. And basically you get all of the people who are affected, random sample, but on a college campus, say, you could actually get all of the students to sit down in small groups with moderators, in plenary sessions with experts who would tell them about the speech, they would discuss with each other the harms, the benefits, the burdens, and then you would have the students decide what kind of speech code do we want on our campus. Now, it's hard to do that in national society, but the idea is maybe if the next generation learns to engage with each other around speech norms, then maybe they will bring those skills out into the wider society. So maybe we don't want government regulation of social media, but maybe we do want more public involvement, more social regulation that's rooted in the citizen as opposed to the institution. And so how we do that and how we can get this to be accepted in society, I think is a big challenge. I'm working on it, and I hope that you guys will kind of dialogue with each other about how do we improve social speech regulation as a first step before we kind of throw it away and just go to government regulation.
Thank you very much. Lauren Bonds is the legal director of the ACLU of Kansas. Ms. Bonds previously served as the assistant general counsel for the Service Employees International Union, where she was involved in the union's Fight for 15 campaign. Ms. Bonds is a Kansas native from Hutchinson and attended the University of Kansas for her undergraduate degree, where she was a two-time Division I All-American in track and field. She received her law degree from Duke University. So Ms. Bonds, my question to you is Jayhawk or Blue Devil?
Jayhawk all the way until they're out of the tournament, then I switch sides. Thank you, and thank you guys all for being here today. So as was mentioned, I work for the ACLU of Kansas, and I think a lot of folks have certain impressions about the ACLU. We're seated on the left side here, and I think that kind of goes along with some people. Yeah, we're going further and further left. But we're seated on the left side here with the press, I think that it's reasonable that folks have that impression that we're a kind of left-leaning organization that's trying to promote progressive values. But I would say that we have kind of an expansive view of what progressive values are, and to us, we really feel like the Constitution is our client. That's something we say a lot. That's something we believe, and I think that's something that that's a value that we actually live pretty frequently. I would just say I do want to acknowledge that our organization is kind of at a moment of reckoning, both locally here at the ACLU of Kansas and then nationally. So in the past, our position has always been, more or less the position that was articulated in the case Whitney versus California, that, the answer to bad speech is more speech. So regardless of whether we agree with something, let's just let all the ideas fight themselves out in the marketplace of ideas. But after Charlottesville, the ACLU represented the Unite the Right rally organizers, and obviously that went from something that was speech to something that was violent, something that was originally just supposed to be people assembling to people assembling with arms. And I think it came at around the same time when our organization was also investing a lot of resources into, figuring out ways that we can make America more inclusive for everybody. So the Muslim ban, that was the ACLU that was, serving as the attorneys on that case, family separation, kind of all these issues. And so we had these two, what felt like really inconsistent positions that we were advancing. And I think that's really sparked a conversation in our organization whether we can do both. And I think really what we're coming to is yes, we can, because all of these rights are protected by the Constitution. And once again, the Constitution is our client. So, and I feel like the First Amendment and our free speech cases are really the place where we have the opportunity to protect everyone's speech and to protect everyone's rights and to be everyone's ACLU. We want more people to feel like we're everyone's lawyer, we're everyone's representative and advocate. And so that's something we've been working on at the local level. So I'll step back and talk a little bit about some of the cases we've been involved in recently. So most recently, we are representing the students who dropped the banners in the State House. So I don't know if you saw that. They're around the time of the debates during Medicaid expansion, our clients who are students at K-State dropped these very large banners with red blood, supposed to be blood handprints that said blood on their hands and then identified members of the Senate and House leadership. So that's not what we're representing them for, that you can regulate banners that are dropping down and hitting people on their head. But the State House, we feel, has overly restrictive regulations that prevent you from having any kind of sign in a place of government. And the people who need to be able to come into government are protesters, because they don't have a representative in the legislature. So they're not going to be able to just say, I'm going to go talk to my representative, I'm going to go talk to my senator. They're going to need these other forms of these other channels to communicate their message to power. And so we're representing them. And so I think one of the questions we've been getting a lot since we decided to bring that case is, well, what are you going to do if the Phelpses want to come in with these signs? And our position is, I think they should be able to, assuming that there's nothing threatening in their signs. It's probably not language or, information we would agree with or a position we would agree with. But if our clients can go and say that, people aren't passing Medicaid expansion, have blood on their hands, the other side should be able to do the exact same thing. And so that's why I really feel like the First Amendment and our First Amendment cases are the space where we're opening speech for everyone, regardless of the position. Another example of that, we recently just settled this case, but we filed a case on behalf of some students in the Shawnee Mission School District who wanted to walk out in protest of school violence back on April 20th last year. So, and that was a situation where I think it was really represented as, this is March for Our Lives kids, this is, the Women's March infiltrating our schools, and they shouldn't be able to go out there and disrupt class. But what was happening at the Shawnee Mission School District was actually really interesting debate. There were these kids who were figuring out what they wanted their norms to be around speech, and they were having these very respectful and thoughtful conversations about how they wanted to make sure that they were safe in their schools. And the administration was just shutting it down. Some people were saying we should arm teachers. They weren't allowed to speak. And then the kids who were saying we should, pass gun reform. They weren't allowed to speak. And so our case was really to make sure that schools aren't censoring kids just because it's controversial. So that really is kind of where the ACLU, I think, is at right now in terms of its position, its position on free speech, on the First Amendment. I don't think we've changed a lot. I think we've just become more inclusive in terms of some of our other issues we're taking on. But I think at the end of the day, we're still here for unpopular speech, and we're still here to be unpopular. So,
Thank you. Finally, Mr. Michael Roehrman is the executive editor of the Wichita Eagle, which is Kansas's largest newspaper by circulation. He's a seventh-generation Kansan and a Wichita native. He started at the Eagle in 1996 while he was a student at Wichita State University, a shocker.
Are there any other shockers around? Surrounded by KU people. Sorry, go ahead.
While working at the Eagle, he helped to launch the website, which became Kansas.com. Notably, Mr. Roehrman oversaw the Eagle's coverage of the deadly swatting incident that Mr. McAllister mentioned, which earned a President's Award from McClatchy, the Wichita Eagle's parent company. Mr. Roehrman is the third generation in his family to work for the Eagle, which included his maternal grandmother and great-grandmother.
So I should start by saying I'm an editor, not an orator, so I'm going to be looking down and reading a whole lot during this. I am the editor of the state's largest newspaper, so it may come as a surprise that the freedom of the press is not my favorite part of the First Amendment. I find freedom of speech and the free exercise of religion to be such remarkable concepts that as a citizen of the United States, I hold those dearest to my heart. As a journalist, however, I have an abiding love for the freedom of the press. I believe that good journalism, true journalism, is essential to our freedoms. I think it is an oxygen for our democracy, and without it, we will weaken and we will fail. When they wrote the Bill of Rights, the founding fathers focused on the individual, on citizens. The initial Bill of Rights, aside from the 10th, every one of them was about people. The one exception, the one institution that they singled out was the press. And from that came the term Fourth Estate, this shadow fourth branch of government holding the other three branches accountable. And I think that's appropriate because I think the press is a lot like the government itself. Many people criticize it and few people defend it. Both entities can do a lot of good and sometimes they really disappoint us. But I think the press, like the government, does both. They can disappoint, but it often is doing good. I think it's important to know that current understanding of the press and what its freedoms mean is a rather modern construction, though. At the time of the Revolution, freedom of the press meant the freedom to denounce King George III, and the idea of holding government accountable meant looking at the arbitrary decisions made by Britain. From the 1970s through the early 20th century, people basically accepted that newspapers and other publications were sponsored by political parties and factions, and that they were promoting agendas. Even my paper, The Eagle, was started when the city's founders brought in Marshall Murdoch to launch a newspaper to sell people on moving to Wichita. That was its purpose. This place is awesome. We have, strong men, beautiful women, and abundant countryside. You really want to live here. This type of press, though, was ultimately replaced in the 20th century when newspapers, which at their core are businesses, realized they need to reach as many people as possible, and taking positions on things was bad business. Excuse me. And as we enter the 20th century and that model of journalism changed, that's when we started getting the Supreme Court decisions that better clarified what freedom of the press was. It's where we've got the decisions that included prior restraint by the government and libel of public figures. And it also set the parameters that the power of the press isn't an absolute. Much like in freedom of speech, where you can't yell fire in a crowded theater. For journalists, it means that if the government comes and says you have to tell us your source on this, in a lot of cases you're going to have to do that. It's not complete freedom. But at the same time, the court also, as has been pointed out, upheld those freedoms. In the Pentagon Papers case in the 1970s, it first entered the district court level, and it was a brand new judge, Murray Gerfine, who heard it. And he basically questioned the patriotism of the New York Times for wanting to publish this. But at the same time, he provided an unequivocal endorsement of the First Amendment. He said a cantankerous press, an obstinate press, a ubiquitous press must be suffered by those in authority to preserve the even greater values of freedom of expression and the right of the people to know. This has been the genius of our institutions throughout our history. It is one of the marked traits of our national life that distinguish us from other nations under different forms of government. And now we're getting into the 21st century, and we have this multitude of voices, and we have advocacy journalism showing up again. And it's basically everything old is new again. This is exactly what was happening in the 1700s and the 1800s. The difference now, as noted, is the speed at which this gets disseminated and vast distances that it can go over. But the bedrock principle established by the First Amendment, the basic concept of holding those in positions of power to account, remains unchanged in its potency, and God bless the Founding Fathers for putting it in there.
Thank you very much. Ladies and gentlemen, this is the point now where we will open up the discussion for your questions. So we have a roaming microphone. If you raise your hand if you have a question, we'll go ahead and bring the microphone to you. If you would identify to whom the question is addressed, if there's a specific member of the panel, or otherwise just let us know if it is a question to the panel at large. So if anybody has a question, if not, I'll go ahead and start things off as you're thinking. This is just a general question to the panel members. So over the past 3 years, the FBI has tracked a steady increase in the number of hate crimes reported. Many people attribute this to a corresponding surge in hate speech. And some public institutions, particularly universities, they have attempted to establish speech codes. Do you think the United States should follow countries like the United Kingdom or Germany and outlaw certain types of speech, or how should that be addressed?
Well, I'll say this much. If the United States does follow Austria, Germany, France, a number of the European countries that after World War II have criminalized certain things you can't say, certain symbols you cannot use, that sort of thing, this Supreme Court will strike it down as unconstitutional. So, I mean, it's sort of an academic question in that sense. This Supreme Court had even the Virginia versus Black case a number of years ago where a cross was burnt by Klansmen, and they tried to prosecute them under Virginia law, and virtually the entire court said, no, you cannot do that unless you show this was intended as a true threat, basically, against certain individuals. Justice Thomas, I think, in a very poignant opinion, said, wait a minute, what other purpose is there for burning a cross than to intimidate and threaten African Americans in the United States? But a strong majority said, we're just not going to go that route. So I think at least, I think we can have an argument about whether it might be a good idea or not. I'm just saying, as a matter of current doctrine, it would not stand in this Supreme Court under our First Amendment.
Thank you. Any other comments?
I guess just to kind of dovetail off of what Stephen said, one thing that I've always found very, very interesting is how historical context played a role in how this free speech doctrine evolved on both sides of the Atlantic. So on the one hand, you had, kind of Europe's kind of free speech, because everyone started off with just prior restraint, which means don't stop people from speaking, right? But then different historical circumstances caused them to go in very different ways. So you had the World War II issue, which, post-World War II, you still have kind of this kind of anti-Semitism. And so what, kind of the UK did, I think, and most of Europe, they kind of leveled up, like everyone is going to be entitled to this, respect and this dignity and kind of treated, with kind of equal citizenship. So we're not going to allow hate speech. But the context of the U.S. was a little bit different, because when we were really beginning to think about how libel intersects with free speech law, you had the southern states using libel law to kind of keep northern press from covering the civil rights movement. Like, so you had the New York Times versus Sullivan incident where, they were trying to collect money to get Martin Luther King and other people out of prison for kind of protesting injustices in the South. And, the ad said, they rang the school, officers ringed the school, they starved the students, and, they sang this song. And, the argument was, well, they didn't starve the student, we did, some of these facts are false. And that's true, some of them were accidentally false. But if the court had not constitutionalized our libel law, then the coverage of the civil rights movement, and we kind of know how important the media was to that. So I think part of how we got here was kind of that historical context that made it what Europe was trying to save and protect against required leveling up. What we were trying to protect against required leveling down, and say we can't, we're not going to protect anybody. We're going to kind of allow this kind of speech. And I just think that's very, very interesting. And I don't know. I mean, I wonder if this is a new historical moment, right, that will cause us to go in a different way. I think there are some dangers to that because what is hate speech depends a lot on kind of whether you agree with it or not. So I think it's dangerous, but I think it's possible that we could be in a different historical moment that makes that more acceptable.
Any other comments from our panel members before we go to our next question? Okay, from the audience?
I have something to say about Europe, if that's okay.
If you could get the microphone, there you go.
I just want to say something about Europe because I grew up in Germany and I liked the first freedom of speech. Because if you say something in Europe right now and you say something wrong, your neighbor can turn you in and say, hey, she has hate speech. I do not want that. Do I agree with a lot of this stuff? No. But I want to have the freedom to say what I want to say. And not be afraid that the police comes around and knocks on my door. And that's all I have to say.
Thank you. Just kind of for all of you, a theme came out, these social media platforms and stuff, and current laws that these digital platforms aren't liable for comments that are posted on them. But there's been some rumblings about modifying that, even abolishing that. So I'm curious what your thoughts are. Do you see a good solution? What benefits, ramifications do you see if there are changes to Section 230?
Somebody else start. I mean, I think it's a challenge, but there's so many problems with, I think what Franciska said makes a lot of sense to try to get better insight into who's creating the regulations and setting the norms and that sort of thing. But, under constitutional doctrine, it's not the government, so the First Amendment doesn't apply, and I do think you run the risk. I mean, maybe that's just the marketplace. If Facebook becomes too one-sided in certain kinds of comments it allows or doesn't, people go to another platform. I mean, that would be one answer, and that is typically the historical answer. I think the problem may be that Facebook and Twitter and some of these have become so large and so dominant that I don't know if there is a real competitor that people would be able to go to, but I've said enough. So anyone else want to jump in?
I have so many thoughts, and I'm trying to figure out how to. And part of this is practical. Before I started my career as a digital journalist, and so I was buried in those exact comments on a much smaller scale as opposed to a macro whole social media. And it is a soul-destroying job monitoring and moderating those comments. And if you look at what's happened, there is a mob mentality behind so much of what happens on social media, and it turns into this horrifying things that people's lives can get destroyed by making an inappropriate joke or saying something that was meant for their friends, and the friends would get this and nobody else would. But we do get back to the freedom of speech, and do we regulate ourselves, and does it go back to individual responsibility? Is it up to the person to behave properly and for others to call them out while keeping it from turning into law? And I don't think there's a simple answer to this, but I would always err on the side of not regulating speech in any way if possible.
So related to this topic, and it was mentioned before by General Romig, so it's actually the 100th anniversary of Abrams versus United States, which is the famous case where Justice Oliver Wendell Holmes, in his dissent, coined the phrase marketplace of ideas. In there, Justice Holmes, he previously penned the famous clear and present danger standard that was used to restrict speech. But in Abrams, he said that the ultimate good desired is best reached by free trade of ideas, and that the best test of truth is the power of the thoughts to get itself accepted in the competition of the marketplace. So here we are 100 years later, the platforms have changed dramatically. The volume of comments have gone up dramatically, but is it still the same test that those ideas which are able to catch on in the marketplace of ideas that matter most? So is it still working 100 years later?
So, being the obnoxious person from the ACLU, I will argue that I'm not sure it was working 100 years ago. I mean, as much as our organization and me personally am a strong proponent of a free marketplace of ideas, I don't think that takes into account the fact that people have different power and different privilege. People have different size microphones, and people have different positions in the marketplace. And I think that was the case 100 years ago. I think that's the case out in kind of brick and mortar protest spaces and places of assembly and speech. And I think that's the case in social media as well. I don't think it's always necessarily the best idea. I think it's the person, or it's an idea that's propagated by a group with privilege and power and money. And that can be economic, that can be racial, that can be religious status. And that's my thought.
But do you think there's also been some equalizing in the sense, I was going to say, talking nowadays about what's the press is really, to me, a curious question. Because you can be a blogger. You just put up your own site, and all of a sudden you're the press. You're commenting on everything. So I guess that would be, there are a lot more people able to participate. I agree, not always the same strength and reach, but compared to 100 years ago, millions of Americans can instantly participate. It's a curious situation to me, but
I think that's a fair point. I think we are democratizing our news outlets and our general access to the public, and so.
So one thing I would add is that volume matters. And if you have so many ideas, you don't have time to weigh and see which one is the good idea. You got to use proxies. Oh, it's a good idea because it was on Fox News. It's a bad idea because Obama said it, And when you get that kind of critical thinking, if that's your measure of what is a good idea and what is a bad idea, then I think the marketplace may be broken. And so I think that may have been a problem they didn't have 100 years ago, and I think it is a problem that comes from this democratization, that now everybody has a platform, but we have the same 24 hours in a day. And I think that makes it more difficult for the good ideas to get, the press that they need and the bad ideas to go down. And then lastly, maybe we were never that good, actually, at because, we're not always rational. We respond to emotional appeals. And so maybe it's actually the emotional appeals that rise to the top and not necessarily the good ideas. So.
I think one of the commentators, maybe even one of the justices said, in this marketplace of ideas, it's not just what people do now, but it's over the long term. And over the long term, so far in this country, truth has risen to the top, so to speak, and perhaps that will continue to be the case. I think we're in a real interesting period of time, and we don't know what impact social media is going to have in the long term on our country. And I don't think the answer is the government regulating social media or regulating the media. I think we've got to find another answer.
We had a question here and then over.
Hello. I know, Mr. Roehrman, you mentioned something about a source privilege for journalists. We have a lot of attorneys in the room, and I'm pretty sure if you're not an attorney, you're still familiar with the concept of attorney-client privilege. Do you think there should be some kind of journalist source privilege? And I'm also interested to hear Mr. McAllister's thought on this as well, as the top federal prosecutor in the state.
I think unless there is an overwhelming reason to believe danger exists, yes, there should be. I don't think journalism should get in the way of safety. But beyond that, yes, because too often people are afraid for whatever reason, for their personal safety, for their employment, to come forward and speak. But doing it via journalists, they can. And I think they should be protected, especially, I mean, your general whistleblower laws. This is how the public is going to find out what they need to find out. And we should protect people over here as well.
Yeah, I would say I see two different aspects to that. There's nothing that keeps, my understanding, federal or state law from statutorily enacting a reporter's privilege that I don't know that government could necessarily then overcome. The cases the Supreme Court has had have involved the question, does the First Amendment effectively create that? And my old boss, one of my old bosses, Justice White, has a couple of notable opinions in that territory. I don't know if it was because he was pestered when he was an All-American football player and a Rhodes Scholar and got tired of the press, but he was never really fond of them. And so there's a case called Brandsburg versus Hayes where the reporter, I think, was subpoenaed by a grand jury to come talk about their source. They refused. They were held in contempt and put in jail, and the court said, sorry, there's no constitutional protection for that. You can be subpoenaed just like anyone else can be to come testify. And similarly, there's a case called Cohen versus Cal's Media in which a reporter promised a source confidentiality. Reporter went to the editor with the story. The editor said, you know what? The name of your source is actually more interesting than your story. So let's publish the source's name. And the source then sued the paper, and the paper said, you can't do that. We're journalists, the press, we can publish any information we want. It's true, it's not false. And the Supreme Court again said, no, you're like other entities. You can make a contract with somebody, you can be sued for breach of contract. So they actually let the paper be sued by the source who thought he was anonymous, and it turned out he wasn't. And I guess as a constitutional matter, at least the current doctrine does not give the press that protection, but I don't see anything that prohibits Congress or state legislatures from creating a reporter's privilege, and I think some jurisdictions have done that to some extent.
I think we had a question, the gentleman in the red shirt.
Hello, my question's for the panel. First off, thanks for coming. Thank you for your opening remarks. Very impressive. My question deals with Julian Assange and WikiLeaks. Sources, the information are dubious. The information itself seems, accurate, truthful. Should he be charged with any crime here in the United States? Any crime? And what would you say, if you do think so, what would you say to people that think that is just some kind of smokescreen or sour grapes from people charging him? Thank you.
That one I can't answer. I think he may be within DOJ sites, so I'm not going to comment on his situation, but I will let the others comment.
I'm leaving that up to the lawyers.
Wow. So, I don't believe the ACLU is representing Mr. Assange. I believe that there are other people in his kind of class of whistleblower that we are representing. I would take the position that well, I don't want to go into it too much. I think I would want to see what kind of charges would be brought. I mean, based on the information I have, which is what's available through the press, to my knowledge, I'm not 100% sure that there is a, that he, yeah, so I don't want to go into it too much. I will just say that, I'll just take the position I'm not coming to you either.
I would say that probably not enough is known to be able to give you an accurate answer at this point. We would need to know exactly what he had done before we could have a true opinion.
The allegations are he helped Chelsea Manning try to hack into a computer. So if he was charged with that.
You gotta turn back over to the lawyers. I was just marking it.
Well, I think what he will try to do is cloak himself in as a member of the media, as a member of the free press, but being actively involved in hacking into somebody's or the government's emails, he kind of strips that facade off of protection of being a part of the media. If he had only received the information, he might have a much stronger case. But I don't think he has a real strong one if he's involved in the hacking, which I think the facts indicate.
Yeah, I will add to that. So we do prosecute people who hack into computer systems. We obviously prosecute spies who turn over classified information to foreign nationals, foreign governments. So, I mean, you know, when it's that active and it's that kind of a national security threat, yes, there could be a criminal prosecution. I don't think it would be protected. And there's certainly cases that say, basically, if the newspaper received this without participating in any unlawful action, that's kind of the Pentagon Papers, and it's truthful information, you can't punish the newspaper for publishing it. But if the newspaper hires people to go hack into the computers or to steal, or it bribes the government employees to turn over classified information, that's a different case. Then I think they're involved in criminal activity. The First Amendment will not protect.
Hello, my question is for Ms. Mons and anyone else that would like to contribute. You mentioned that the ACLU is currently at a crossroads in determining if it's going to value what's kind of in its bedrock throughout its existence is the right to free speech versus, these are my words, maybe optimizing the outcome of the use of speech. And what issues do you see in particular with evaluating on a case-by-case basis, trying to optimize an issue versus standing by that principle, and who should be, or whom should be the individuals making that choice?
So I think that's an excellent question. I think it really encapsulates kind of what's going on. That's a conversation I think we're having internally very, very regularly, right? So I would say, kind of the first part of the question, kind of the competition between the bedrock principle and like kind of these more optimization goals. I like that word. So, I would say that we're still 100% committed to our bedrock principles, because I don't think optimization, anything else can happen if you don't have the First Amendment, if it's not strong, if it's not protected. That's freedom of speech, that's freedom of religion, that's freedom of press. And I think that's just an analysis that, as an organization, that we've done. And I think why it's the very First Amendment in the Bill of Rights, because I think that's an analysis that the Founding Fathers probably did as well. I think as to the question of who makes that decision, I think that's one of the great things about being part of a civil society organization like the ACLU or a nonprofit organization. We can make that evaluation for our organization, and it's great because other organizations who might take a different perspective, so maybe the NAACP, the Southern Poverty Law Center, they can take that position and support kind of these other goals, and we're all getting the work done that I think is making society better without compromising our values. If that makes sense.
I think we have a question over here.
Okay, I'm double dipping tonight. So a big issue in free speech law is social media, the proliferation of social media. On the one hand, and there's a question kind of that's in tension in my mind, and I'm hoping you can resolve it. Professor Coleman, your remarks kind of prompted this question, but of course it's open to the whole panel. On the one hand, people view social media as a platform for censoring certain types of speech, offensive speech, speech that has the potential to be very harmful to certain groups. But on the other hand, there's people who at the same time like to view social media as this public forum. For example, when a public official blocks someone on Twitter, is that a violation of rights? So my question to the panel is free speech this sort of incubator to help check hate? Or is it more of a just a fully public forum with full protections of the First Amendment?
So I'm not sure that there's been kind of a consensus around that just yet. I do know that one of the arguments for treating Facebook kind of as a public forum is that the function of Facebook and kind of having these discussions and these debates, it's kind of a forum where a lot of political speech, you know, all of the politicians are on it, all government organizations, and so it begins to look like, I guess, I don't know, I would see what Steve thought about this, like a company town. And so the company town is, you know, it's like it doesn't look private anymore. It's so open to the public and so relied upon by government officials that it begins to seem like another kind of like a street, like it's like the street of a city. And so that argument, I think, is one maybe for kind of treating it as something that should be regulated and preventing hate speech. I think the other is, you know, people post their family pictures, and I can exclude who I want to exclude, and I can include who I want to include, and so that makes it seem more like a kind of a private forum where we kind of discuss these things. You know, we're going to kind of promote, you know, tolerance, and so it doesn't seem like it should be regulated. I think when the speaker is the government on Facebook, then I think definitely we should treat it like a public forum and there should be no censorship. But when it's a private speaker, then I think using it in a more private way, kind of upholding these kind of restrictions and these kind of limitations, I think people are still debating about whether that's okay or not. I think hopefully that was responsive to your question.
No, and I think what she was referring to with the company town is an old Supreme Court case where Jehovah's Witnesses showed up and the company literally owns the entire town, so there's no public property in the town, and the Jehovah's want to do what they do, and the answer is you can't. It's against the law, and they took that all the way to the Supreme Court, and the Supreme Court said, wait a minute, this is a town in every respect except the company owns all the property. So if it looks like a public forum, we're going to treat it like a public forum. And I do think there's an argument in the social media context for that, but there's also counter arguments that, you know, maybe the court will resolve it one day, maybe the legislative branches will try something that will lead to a resolution. But I certainly don't know what the answer is. I see the arguments both ways, that you could call it a public forum, but you could also say, no, it's not. So it's a difficult question, but becoming more and more important, I think.
Anybody else? I'm going to throw mine in too, since I've got the mic. So I'm going to bring some history back to this on two fronts. We have some quotes from Eisenhower I thought might be appropriate. One of those that he gave in a remarks to the National Society of the Daughters of the American Revolution was, I believe the only way to protect my own rights is to protect the rights of others. That's one. My second question is kind of related to that, and another quote of Eisenhower's in that, Dr. Coleman, you mentioned education and seeing how that plays out. How do you see, all of the panel see the role of education, schools in civic education and this issue? And I'll quote of Eisenhower's again is, the true purpose of education is to prepare young men and women for effective citizenship in a free form of government.
She mentioned you, so.
You inspired the question.
Not the first person. So yes, I'm a strong believer in the power of education, and that kind of causes me to be a little schizophrenic on the First Amendment, because I do believe schools are the place to kind of teach these skills to students of social regulation of speech. How do you do that in a way that's not dominating, that's just silencing, right? How do you do it in a way that's respectful and that kind of shows your boundaries, respects their boundaries? But I think ideally that would happen in public school. The problem is public schools are extremely homogenous, right? And so when you actually realize that this is offensive to another group, that's going to be college, right? And so I think actually it's going to have to be the university where we begin to kind of teach these skills. And I think when you're modeling social regulation, some things are going to have to be out of bounds, right? So that's not free speech absolutism, right? That's letting these colleges make these codes. But I think it needs to be, I think we need to model the kind of speech regulation in colleges that we want students to use in society. And so I think we need to not be silencing students, not have punitive measures, but I think try to engage students in deliberation, right, in negotiation around these issues. And I think, in terms of education, I think this modeling and this kind of scaffolding their efforts to figure out how do we navigate these speech norms and how do we create them, then that I think is essential. Because students, one of the things I tell my students all the time, like, you guys are so passionate. And that is a compliment to them, but it's also, a bless their hearts kind of thing. Because they're in college, because their passion right now is not totally unified with the current state of knowledge, right? And so they have a lot of passion, they're really kind of absolute, certainties. And I think part of our job is to kind of help them kind of come to compromise and negotiated positions. And I think you can do that also through modeling and through speech, because just letting them kind of not giving them any boundaries and not modeling this means what happens to many people. The first time that they really understand how this speech is affecting other people is when they are tweeted about and they lose their job, right? And so I think before we get to that point, we do need this modeling and scaffolding. So I think education is crucial.
I think it's really even a bigger question than just free speech, free press, and that. I'm pretty removed from what kids in grade school are now being taught, since our children are now in their 40s. My wife will correct me on this, I'm sure. My supposition is that civics is not being taught in grade school much anymore. And consequently, we have people who are ignorant, illiterate, as in regards to the function of government, the roles of the different components of government. And when you have that, they become much more susceptible to, if you want to call it fake news or other opinions that aren't necessarily grounded in fact or logic. And so that's one of my concerns, is that we have a growing gap of public knowledge of our institutions. And so, as I say, I think it's a bigger question than just the two clauses we're talking about in the First Amendment.
I would just note, as a millennial on the panel, and having just recently worked with some students in a First Amendment case, I would say I kind of noticed something similar. I think Gen Zers and millennials, I think they have a very different relationship with the First Amendment than older people. And I mean, I think that's borne out in all the surveys you see. About 40% of people under the age of 30 think that you should be able to criminalize or ban hate speech, where the general population of America is much closer to 10 to 15%. And so I do think that, I don't know if that's a civics issue. I don't know if it's we shouldn't be coddling kids so much where they're afraid, like, don't want to call everyone snowflakes or anything, but I do think that there is not enough space in even before university, for people to deal with, information or ideas that is uncomfortable to them. And I think, that's in large part because there's this kind of competition between the First Amendment and, Title IX, or the First Amendment and, Title VI, which, protect against discrimination and harassment in educational places. Obviously, the Constitution trumps statutes. But I do think that, administrators of schools are trying to weigh these two things. And I think it's kind of a missed opportunity to try to use the different doctrines of school speech to shut down these conversations, because I do think most kids, if they had the opportunity to engage, can do so respectfully. And maybe I'm wrong about that, but I do think your point about education and having the chance to kind of model what's appropriate conversation is incredibly important, and it's going to be really important to protecting these kind of constitutional values that some of the older folks have. So.
I've worked for media companies, and what I wanted to make sure of, if I understand this, is it the federal government, state government, they're the only ones that can be sued for violation of the First Amendment? Or were you talking about if something's a public forum or seen as a public forum, but it's a private entity, how would somebody be held in violation of stopping somebody's First Amendment rights, if they can at all?
So First Amendment applies to states and local governments through the 14th Amendment, which has a prohibition on state action. So you've got to have state action, governmental action to implicate the First Amendment, unless you're talking about the federal government, which is covered directly by the First Amendment. So just because you have a public forum, suppose you have a public square. If the government officials are not the ones in there disrupting or shutting down or interfering with speech, say it's private citizens who don't like what they see, and they go over and attack the people holding the signs, it's not a First Amendment violation. Now, it will be battery, assault, it could be tort claims. I mean, there are a variety of legal claims that could be brought against those people, but it would not be for a First Amendment violation unless it's the government, which is why you get this question of, do entities like Facebook become so much like government in a real sense that they ought to be treated as state actors, and therefore the First Amendment would apply to their decisions. But under current doctrine, the answer is no, that would not be a First Amendment violation.
I think we have time for one more question.
It's never good. You never want to go last. So you all talked a lot about using education and then the difference in the power base. And my concern with using college students is that not everybody goes to college. And so if you only teach college students to discuss social norms respectfully, how do you deal with the majority of the population that never reached that point? Are you just creating a new group of disenfranchised individuals who may be the majority but are powerless because they don't have the ability to speak and have the dialogue with those who are taught to be respectful and are therefore just pushed to the wayside? How do you teach those people how to have respectful conversations and to understand that they deserve the respect, using the First Amendment and say you have the power to get up and say what you believe just because you didn't go to college and you didn't use these words? How do you use education to bring people together? Because it sounds more like if you're trying to use education in college to talk about social norms, all you're doing is creating two new strata within our society.
Right, I think that's a very good point, and I have a couple of responses. So one response is one of the criticisms of hate speech, I think this was by Robert Post, was if you have a law against hate speech, the well-educated person is always going to be able to say their critique in a way that gets by the law, but it's the uneducated person who's only going to have the rough and ready, maybe F-bombs, I don't know, to kind of really get their point across. And so that's a point that's well taken. The reason that is university, however, that would be my suggestion. I think ideally it would be high school. The problem is, I don't know about you guys, but for myself, my high school was basically all African American, all Christian, right? My students, when I asked them their high school, all European Americans, all small town people, and so you don't have the clash of ideas that you need in order to teach. It's very difficult to teach engagement with controversial ideas in a place where everybody's kind of agreeing and you don't have this disagreement. So I think that's so ultimately I would say start with college, integrate, the schools and get some diversity there, and then I think you can have these discussions. But I think you need different bodies in the building in order to really teach this engagement with difference. But I think that in the interim, then yes, you should maybe try to find other fora to teach this, but we're still a very segregated society, so I don't know. I mean, you could do civics. I think definitely teach civics, but I think teach this kind of in the midst negotiation with somebody who just said something that I thought was sexist, right? Then I think you need that sexist person there, in order to kind of show and have that conversation. But I think you definitely make an excellent point. We don't want a two-tier society, so that's something we have to consider.
Yeah, and just to that point, I think that in addition to what Professor Coleman already noted, it's not as open a forum in a high school or in a middle school. I think we recognize that when kids are younger, it's reasonable for schools to apply more restrictions, and disruptions are more likely just because there is a little bit of maturity that happens between 17 and 19 or 15 and 20. But that being said, I think you make a really good point about this not being something that we can being a citizen isn't something that we should only learn in college or even in a formal education setting. And I think that's why it's so important that the First Amendment be used to ensure that there's protection of the right to protest. Protest is open to everybody. The right to assemble is open to everybody. And so I think that, the First Amendment really has a role in making sure everyone has a voice and everyone has a chance to state their opinion. When we look outside of kind of more formal, kind of regulated, comfortable forms of speech and look to, protest, when we look to more disruptive types of engagement with each other. And I think that's what's, super important to the ACLU right now, is making sure that stays open in addition to, speaking on the internet and more civilized forms of communicating.
Okay, well, that concludes our evening. I want to thank our audience for attending and viewing this Law Day event on free speech, free press, and free society. Again, a reminder that the opinions expressed this evening are those of the presenters and not of the U.S. government, whether that's the Department of the Army or the Department of Justice. I want to especially thank the Eisenhower Presidential Library and staff for their warm welcome and for hosting this event, and from my office, Captain Thomas Wheatley for facilitating this discussion. And finally, and most importantly, I want to thank our distinguished panel for their thought-provoking comments on this very important topic. So let's give them a round of applause.